number 77, the people of the state of New York versus Lamb. Counsel?
Good afternoon, Your Honors. My name is Mark Zeno, and I represent appellant Michael Lamb. May I reserve 2 minutes for a rebuttal?
2 minutes, sir?
2 minutes, please.
Yes, you may.
May it please the court. The court below erred in its interpretation of the sex trafficking statute. That error affected the resolution of two critical issues at the trial. First, the court erred in holding that New York had geographic jurisdiction to prosecute Mr. Lamb for trafficking Jasmine C. And second, the court erred when it answered a jury note and told the jury that the people were not required to prove that Mr. Lamb advanced prostitution by trafficking a specified person. The actus reus...
Counsel, I'm sorry.
Sure.
Is part of your argument, at least, is that this is a one-element crime? Is that right?
I don't really think it's correctly characterized as a one-element
Okay.
crime. I would agree that there are multiple things that the people have to prove. They have to prove that my client profited or advanced prostitution, and they have to prove that he did so in a specified way through specified coercive conduct. But the statute links those elements by use of the word by. And so, yes, there's more than one element, but that one element is tethered to the other element. So it's not a standalone element.
I understand that argument. So would you, and I know there was no objection at trial, would you agree that the initial charge was correct?
The initial charge was correct, yes.
So your position is it was the supplemental charge that undid the original charge?
That's correct. The initial charge, which followed the CJI, was correct.
What if, and I know this isn't the case, but let's say you flipped the conduct here, right? So you had, let's call them the threats for shorthand, in New York, and you had the other activity in New Jersey. Could you charge it to say, during the relevant period, the defendant advanced prostitution and profited from prostitution, and that he did so by threatening this person in New York? Would that be okay?
Threatening the person in New York with the goal of coercing her to
whatever
be
the
a
language is in
prostitute
Part
in New
B.
Jersey, then yes, I do think that would be sufficient, because the intended result was, he manifested his intent, his criminal intent, to promote prostitution in New York in New Jersey, by
Right.
the threats in New York.
Okay.
So is your argument that someone could never be prosecuted, or we can never find jurisdiction for threats that occur outside the state if someone is advancing an enterprise in New York State? Or you're just saying in this particular case, because of that bridge between the two parts of the charge, haven't been met? I'm just trying to understand your argument.
Right, so I would never say never. There needs to be proof of a connection that the threats were for the purpose of inducing the end result in New York, which was the prostitution.
So it's not the fact that it was out-of-state conduct per se, it's the fact that you think the people failed in establishing that connection.
Correct. If they had shown with proof, that his intent was to force Jasmine C. to become a prostitute in New York State, then that would have been sufficient. But there was no proof whatsoever that was the intended result.
Well, it seems more, counsel, though, your argument, that to me sounds a little too much like a sufficiency argument. I understood your argument to be the instruction itself the supplemental instruction disassociated the parts, so they didn't need to find that, right?
Well, there are two separate arguments. There are two separate errors here. There's the geographic jurisdiction issue as a pure question of whether the people proved the sufficient connection. And then there's the second issue when the court responded to the jury note telling them that the two elements didn't need to be linked. That was not a meaningful and accurate response to the jury's question.
But you're not making a legal sufficiency argument, are you?
Well, I think geographic jurisdiction and legal sufficiency, there was not sufficient evidence of jurisdiction, so to that extent, it is a legal sufficiency argument.
So it's your argument that we have to, in essence, adopt Judge Titone's dissent in Giordano. Is that what you're saying to us?
Well, I have
I'm not
trouble
trying to
with
trick you or trap you. I understand it's always reluctant. Anybody would naturally be reluctant to argue, but it's some of the analysis.
Well,
anyway.
I think that's a more correct analysis. I don't think that the court has to find that Giordano was wrongly decided. Giordano was a venue issue for one, and this is a geographic jurisdiction. One deals with just a choice of counties. The other deals with the power of the court to prosecute. And the other is that there are significant differences between the promoting prostitution article, Article 240, and sex trafficking on the one hand versus the promoting gambling article on the other. Promoting gambling in the first degree, which was at issue in Giordano, was an enhancement offense. It was an enhancement of the base level of promoting gambling. As we argue in our briefs, sex trafficking, it stands totally apart from promoting prostitution, which is the corollary to Giordano. For example, there are other promoting prostitution offenses. There are a range of them with different levels of severity based on the conduct, including promoting prostitution in the second degree, which penalizes advancing prostitution by compelling a person by force or intimidation to become a prostitute. I mean, that's the enhancement offense. That's the corollary to Giordano.
It seems, though, that there are, I, in my mind, identify three specific public policy implications of what you're arguing, or at least what we should look at. First being the validity of the precedent itself in Giordano. The second being how that would affect the limits of state jurisdiction in our analysis of the elements. And the third being the practicality of policing in an environment where it's totally different from Giordano, and in an environment where communication is almost instantaneous and limitless. How does one police that environment with the kind of, in many ways, impractical analysis of arbitrary lines as controlling the policing powers of the state over particular activities. So those kind of activities, it all kind of fits in within that. And I have to admit, I'm a little lost in saying that we should separate the jurisdictional analysis from the jury note analysis, because it seems to me that they rise or fall together. So those are my problems with it.
That's a lot to answer.
I know. So pick your poison.
Let
Go
me
ahead.
start with the policing aspect of it. I mean, the answer is that cooperation between, state police offices is the answer to this. New Jersey's right next door. New Jersey could have prosecuted this as sex trafficking. They have their own sex trafficking statute. These actions took place between New Jersey citizens in New Jersey. So a phone call might have been the easy answer to that. And I see my red light is on, but if I could just for a
Yes, you
a
may,
minute.
sir.
In terms of the linkage, they are certainly linked. That the by means, is a limiting causal word. It creates a causal
Well, that's what I was
connection.
thinking. Not necessarily, forgetting about how you come out on it, it seems to me that it's very hard to separate those two issues in any legal analysis. If we give an instruction on jurisprudence, and it's a factual question, then we clearly is going to bleed into the jury instruction.
Well, they bleed together, Judge. They really do. But one is finding one is working. We're sort of compelled to work within the framework of Giordano to some extent on the jurisdictional issue. But one is a simple causation question. The statute, and that's the jury note answer.
But you see what you were arguing. We'd have to say by means one thing on the jurisdictional issue, but it means something else when we get to the jury note. That doesn't make a lot of sense to me.
Well, I agree that the plain meaning of by in these circumstances seems very clear to me. It says you promote prostitution by a threat. You have to prove that connection. You have to prove that the threat promoted prostitution. To me, it's not complicated. Giordano, I agree, complicates the analysis.
Yeah, but for jurisdiction, why is it not simply in a multi-element charge? If one of the elements was in the jurisdiction, then you are allowed to prosecute it. I mean, are we really saying that when confronted with a trafficking operation in New York, we should pick up the phone and call New Jersey and ask them to prosecute it for us?
We are saying that if the language of this statute requires that you promote prostitution by a particular action. So you can't just say an element occurred in New York. Yes, there was promoting prostitution in New York, and we don't contest that, but the statute as drafted requires that you promote prostitution by a particular action. You know, there are a range of types of threatening conduct here, some of which are not even illegal, some of which are not even tied to prostitution that are covered by this statute. For example, withholding a passport. So if somebody withholds a passport in New Jersey for unconnected with trying to promote prostitution, for example, and they also promote prostitution in New York, by your suggested reading, you could prosecute them for sex trafficking in New York because one of the elements occurred in New York, and that the statute just doesn't permit that. It wasn't designed for that purpose.
But I think that goes back to Judge Garcia's point that it's more like a sufficiency, because then the answer is maybe that's a not guilty, or maybe that's a trial order of dismissal, but not that there's no jurisdiction, because if there was the connection, would you agree that there would be jurisdiction?
If there was.
If the people had adequately connected the coercive action with the operation in New York, would there be jurisdiction in New York?
Yes, because then the by would operate correctly as it's intended in the statute.
So that it is more sufficiency than jurisdiction.
Well, again, sufficiency of proof of jurisdiction. And yes, we have to interpret what the word by means to determine whether there was sufficient proof of jurisdiction.
Hypothetically, if the defendant here had said, I'm going to tell your father all about this unless you show up at this address in Manhattan on Tuesday night, that seems to satisfy the by requirement.
It would.
So jurisdiction would be present in that scenario.
If the by was satisfied, correct, I agree.
Thank you, counsel. Counsel?
Good afternoon, Your Honors, and may it please the Court. John Hughes for the people. New York has jurisdiction if any element of a crime was fulfilled here. And in this
Counsel, let me
case,
ask you on that point.
Yes.
So let's say the defendant has the same type of operation as this case in New York. It's a multi-state kind of recruiting in Jersey, whatever. And then he goes to California to visit some friends, and they have their own operation out there. And they say, we could really use your help out there. You're good at this. Could you go out and help us with this one person we really want to threaten and coerce her into becoming... And he does that. And they say, thanks a lot, you really helped us out here. And he flies back to New York. Do you have a sex trafficking count in New York?
under those facts, I think probably not. And there's one thing I want to clear up here. Our position is not that, the elements of this crime can be completely unrelated to one another, like in the example you gave. I would say that these, statutes have to relate to one another in one sense. Just that as long as the coercive acts, as was proven here, are meant to further the same multi-state prostitution enterprise that we proved that defendant was running in this case, that's sufficient for jurisdiction.
Why didn't the supplemental instruction sever that requirement?
Well, as I understand, defendant's objection, first of all, the jury note was simply asking about whether the element one for advancing or profiting from prostitution has to relate to the same person as the person who is the victim of the actual coercive acts that's described in element two. So that was really the only issue that the court was responding to.
But it seems like with that supplemental instruction, a jury could convict a defendant of sex trafficking in New York under my hypothetical.
Well, here, Your Honor, first of all, I think we absolutely proved that that defendant's prostitution enterprise was meant to be furthered by the course of acts that he actually committed in this case, with which he was like threatening the victim. So here I think.
But that's a harmless error kind of analysis, right?
Well, I don't
I
think
mean,
there was
that's
a
a bad charge, but it's okay because they would have had to find this anyway, kind of.
Well, in the first
argument.
place, Your Honor, the defendant did not raise any objection to the initial charge
Right.
when it was charging these elements. And the later question was really only about does element 1 and element 2 have to pertain to the same person? So, first of all, the defendant has not preserved any claim about whether the elements were properly charged to the jury in the first place.
So to take your adversary's argument, what does by mean in the context of this statute? Since I take you to state that there doesn't have to be that personal connection between the promotion and the harassment or threatening, whatever it's referred to as. What is by in the statute?
Well, actually, in 2019, when this court decided People v. Roberts, the majority noted that the word by, this preposition can mean many different things in different statutes, depending on the surrounding context.
Okay, what does it mean here?
Well, here I think it simply suggests that the coercive acts need to relate to the prostitution enterprise. That's the subject of the advance or profit from prostitution that constitutes element 1. And also, I want to turn back to Giordano for a
All
minute.
right, so counsel, if I can just clarify now your position, because I think I may have misunderstood your briefing on this. It strikes me that you're now arguing that there's jurisdiction as long as there's profiting in New York, right? That gives you your jurisdiction because you're saying that that's a separate element, but that actually he could not have been convicted if you didn't connect the conduct in New Jersey to that, let's just use profiting for the moment, profiting from prostitution in New York. Is that your argument?
Yes, we're saying that as long as these two elements, have that kind of relation where the coercive acts are meant to further the prostitution enterprise, then that is sufficient, and we think that was sufficient here in this case.
No, but okay, so then why isn't defense appellate counsel correct that it really is then the by links these different ways in which the defendant would indeed commit the crime of sex trafficking as defined in the statute?
Well, as this court
It
found,
strikes me it strikes me that you are now agreeing with his interpretation of the statute, but your position is, but we showed that link, and his position is, you didn't show that link.
So I'm sorry, if you give me a moment, Your Honor. The important point here is simply that the word by does not collapse two elements into one. And that's really what's at the heart of this jurisdiction claim, is how many elements the sex trafficking statute actually has. And that's the question this court already answered in People v. Giordano.
But Giordano, because it is about venue, works from the assumption that all conduct, as was the case there, is occurring within the borders of New York State. The prosecutor wasn't relying on conduct outside the borders of New York State, which is what's going on in this case. Strikes me that you have a real constitutional problem if you're doing what Judge Garcia described in his hypothetical.
Well, I don't think so, Your Honor, because People v. Giordano is important because of its statutory interpretation principles, not because it involved venue as opposed to jurisdiction.
Yes, but if, as you mentioned, the court has already said by can mean different things in different statutes. So for the venue statute, when all conduct is within the borders of New York State, by means whatever Giordano said it had to mean. I don't know that counsel is not arguing for overruling Giordano. Doesn't seem that it necessarily needs to be overruled, given the context of the question as presented there, right? But here, because you yourself are saying you've got to have this link, then by must mean something else.
Well, Your Honor, in Roberts, when this court said that the word by can mean things in different contexts, it was referring to different penal law offenses. I don't think that crimes can be interpreted to have different numbers of elements just because the defense is challenging venue as opposed to jurisdiction. And importantly, too, Giordano, which interpreted the first-degree promoting gambling statute, was decided in 1995. The legislature enacted the sex trafficking statute in 2007. And in doing so, the legislature copied the structure and language of first-degree promoting gambling when it was writing the sex trafficking statute. So therefore, I think we have to presume that the legislature did in fact mean for the sex...
But the legislature, we have to presume, understood the constitutional limitations on the state's ability to prosecute for actions that are disconnected from, at a minimum, some consequence in New York. I mean, it couldn't possibly have intended for New York state prosecutors to drag people in. Well, we'll just take New Jersey since it's just, a train, car ride, bus ride, walk right away, to bring them within New York to prosecute them for actions that only occur and only have consequences in New Jersey. I mean, I would think the New Jersey prosecutors have something to say about that.
Well, Your Honor, I disagree with a premise of that question, which is that this case, in terms of the amount of contacts that this case had with New York, there were many contacts with this one. Defendant was publishing hundreds of ads in New York, recruiting both patrons and sex workers. He sought to recruit young women from homeless shelters in New York to work for him as escorts. His Twitter page labeled his enterprise as Lavish Escorts NYC.
Yeah, but he doesn't dispute that. I think the issue is that the one person that he's convicted on is conduct. He argues it. I know you take a different position. I'm just saying. His argument is all of that conduct occurs in New Jersey, and it's not intended to further the enterprise in New York. So that's where he's saying that's what's missing from the prosecution's case.
Well, no, here I think we absolutely proved that by these coercive acts, he did mean to further the enterprise that was the subject of the advances or profit from prostitution. Element one of the statute.
Can I switch you over to a different subject? I wanted to have you address for a moment or two the pro se brief, and particularly the question as to the sufficiency of the indictment and the Bill of Particulars. So at least as I see, even after the Bill of Particulars is answered, what the defendant gets is timeframes that are about a year long as to when the conduct might have occurred, April 1st of 2014 to April 30th of 2015. And all the Bill of Particulars adds is a location, New York County and elsewhere. So if you imagine that the defendant here is running some sort of big prostitution ring in New York, and the purpose of both the Bill of Particulars and the indictment is to give him, among other things, some ability to know exactly what he's being charged with, how does he know what this is about? How is this sufficient?
Well, Your Honor, I think like this court's decision in D'Angelo, and if you look at the practice commentaries to CPL 200.50, it's clear that for facial sufficiency purposes, it's enough for the indictment to simply include the statutory text. Obviously it includes some timeframes, and supplement that with other details as needed in a Bill of Particulars, such as here where the Bill of Particulars informed defendant that, for example, there were multiple victims. And I would note too that the trial court also...
It didn't even say New Jersey, it said New York County and elsewhere. So, I mean, that might even mislead him, right? He's got a bunch of prostitutes working for him in New York City. This is a year-plus time period. How does that tell him that it's these two that are at issue?
Well, Your Honor, first of all, his enterprise was definitely a multi-state enterprise. He characterizes it as the entire tri-state area. But more to the point, I don't think that there is any requirement that an indictment needs to allege every single county.
How about the Bill of Particulars? Isn't that supposed to give him information that's not recited in the indictment and which pertains to the offense, including the substance, for the purpose of letting him know what he's charged with and being able to prepare a defense?
Well, again, Your Honor, I don't think there's any requirement that if a criminal offense involves multiple states, that every single one of those states has to be mentioned in either the indictment or the Bill of Particulars.
And so when you're prosecuting for acts, for conduct that essentially occurred in New Jersey, the Bill of Particulars is fine when it says New York County.
Well, yes, because here, again, he ran his prostitution enterprise in New York. He even told people it was based here. So I think this absolutely gave him fair notice of the nature of the allegations against him, the time frame that it involved. And furthermore, there's simply no indication that he was actually deprived of any kind of fair notice. He put on a vigorous defense at this trial, and there was simply no indication that, he was at all confused about what the allegations against him were.
Thank you, counsel.
Thank you very much.
Mr. Zeno?
I'd like to return to the geographic jurisdiction and jury note issue. We've talked about what the word by means in the statute and what it meant in the jury instructions. It seems as though the prosecutor's argument is that by here means and, that a person is guilty of sex trafficking if they promote prostitution and commit a threatening act. Not by. The statute doesn't say and, it says by. While I agree by can mean different things in different contexts, that it doesn't mean and here. There is a statute promoting prostitution which covers these crimes. My client was convicted of that crime. But by untethering the promoting prostitution and the threats and telling the jury that my client could be found guilty if he promoted prostitution and made threats rather than promoted prostitution by making threats, the court just changed the whole nature of the offense.
Thank you, counsel.
Thank you.